Mr. Deputy Speaker, sir, most fellow members will agree that a strong and consistent rule of law has contributed to Singapore's success over the years. A key aspect of the rule of law is access to justice, not just for some, but for all Singaporeans, regardless of their means. I would first like to commend the government's readiness to regularly relook this position as our society matures and to shift its policy accordingly. Whereas the government has previously taken a position that criminal legal aid should not be publicly funded, today we are debating a bill that would render assistance to Singapore residents if they are charged with certain criminal offences, so we can build a fairer society based on justice and equality. Speaking as someone who is not legally trained, I would like to seek some clarifications on the bill and the proposed Public Defender's Office. First, from the practical perspective of a person who may use and benefit from the PDO services, and second, on the operational and structural aspects of the PDO. Mr. Deputy Speaker, in Malay, please. Undang-undang tidak boleh hanya menjadi permainan orang kaya atau yang berkemampuan sahaja. Hari ini terdapat pelbagai pilihan untuk orang ramai mendapatkan nasihat atau jawapan undang-undang percuma. Anda boleh menempah janji temu atau dengan klinik undang-undang di CDC dan CC untuk bercakap dengan peguam sukarela. Chatbot iLab di laman web Kementerian Undang-Undang juga menyediakan maklumat undang-undang tentang isu berkaitan keluarga dan penceraian. Sebaliknya, terdapat skim yang lebih kecil untuk orang ramai mendapatkan representasi undang-undang di mahkamah. Rang Undang-Undang Pembela Awam ini bertujuan untuk menyediakan perkara itu untuk warga negara Singapura dan PR yang memenuhi kriteria. Saya faham bahawa siling pendapatan akan ditetapkan pada keluarga 35% terbawah yang mempunyai pendapatan setiap ahli isi rumah tidak melebihi 1,500. Bagaimanakah had ini ditentukan? Adakah siling itu masih terlalu rendah memandangkan family-family yang mempunyai 3 atau 4 ahli melebihi hanya sedikit di atas siling itu masih bergelut untuk membayar yuran guaman RM5,000 hingga RM8,000 yang mungkin dikenakan oleh peguam swasta untuk urusan pembelaan jenayah yang mudah, terutama sekali di dalam konteks situasi inflasi yang tinggi sekarang. Untuk mengelakkan pencanggahan kepentingan, Clause 14 bracket 2 Rang Undang-Undang dengan betul memperuntukkan bahawa PDO tidak boleh bertindak untuk lebih daripada seorang tertuduh atau pihak dalam prosiding yang sama. Walau bagaimanapun, jika terdapat ramai tertuduh bersama yang layak mendapat bantuan PDO, bagaimanakah PDO akan memilih kes yang diambil? Satu lagi tentang memusatkan bantuan guaman secara umum. Dengan penciptaan PDO, adakah terdapat niat untuk memusatkan bantuan guaman menjadi pusat sehenti atau one-stop shop? Rakyat Singapura biasa mungkin tidak tahu agensi khusus mana yang perlu didekati untuk urusan mereka. Sebagai contoh, PDO, skim bantuan undang-undang untuk kesalahan modal kapital atau LASCO dan skim bantuan guaman jenayah, CLAS, akan menyediakan perwakilan undang-undang untuk pelbagai jenis kesalahan jenayah. Biro Bantuan Guaman LAB atau LAB boleh menyediakan perwakilan undang-undang untuk prosiding sivil tertentu. Semua ini juga mesti dibezakan daripada agensi yang memberikan nasihat undang-undang percuma tetapi bukan perwakilan. Saya faham bahawa Clause 12 bracket 5 Rang Undang-Undang telah memberi kuasa kepada Ketua Pembela Awam untuk merujuk permohonan kepada badan atau organisasi lain yang sesuai yang menyediakan perkhidmatan guaman pro bono. Melangkah lebih jauh untuk menyediakan kedai sehenti untuk mengarahkan rakyat Singapura kepada bantuan guaman yang mereka perlukan dan yang mereka layak untuk semuanya pasti akan membantu. Mr. Speaker, in English please. There are some offences that the PDO will not cover and it looks like quite a long list. Some of the excluded offences appear to be offences that ordinary Singaporeans would likely get into trouble for and require legal aid, such as offences under the Road Traffic Act or regulatory offences under the purview of certain statutory boards. As Clause 8 bracket 3 of the bill allows Minister to amend the schedule of excluded offences, how often will the Ministry review the list of excluded offences and potentially reduce some of the exclusions so that more people can benefit? Clause 12 bracket 8 of the bill also helpfully clarifies that a person may still obtain legal representation from the PDO even if he is charged with multiple offences and one or more of them is an excluded offence. However, will such an applicant be treated differently? will he be required to co-pay a pro rata share of the legal expenses corresponding to the excluded offences? Next, on Clause 17 of the bill, which allows the Chief Public Defender to require a legal aid applicant to co-fund his legal defence, would that be the norm or the exception? In principle, some degree of balancing would be required to prevent abuse of the legal aid that is provided. Talking to some lawyers, I have heard stories of legal aid applicants who are less than cooperative with the volunteer lawyers who take up their defence pro bono, especially when the applicants need not fork out a single cent for their defence. So a default co-funding arrangement may not entirely be a bad thing. It will of course be necessary to calibrate the amount of co-funding on a case-by-case basis, considering the applicant's financial and other circumstances. In terms of timing, at which point in time will the applicant be informed of the contributions that he will have to make? So, say for special circumstances, any financial burden should be fully disclosed to the applicant at the outset of the legal aid application. Any uncertainty would detract from the objective of allaying our vulnerable residents' concerns over accumulating legal fees, which is quite important. Moving on to the operational and structural aspects of the PDO, I understand that PDO is targeted to commence operations in end 2022, and the aim is to start by having the PDO employed lawyers to take on all of the PDO's cases before the PDO considers outsourcing cases to qualified lawyers at a later stage. When the PDO commences operations, how many more people will be able to receive full legal representation compared to the present average of 1,400 people who receive full legal representation every year under CLAS? So I hope SPS can help answer that question later on. Another question I have is, what are the conditions to be satisfied before PDO will consider outsourcing cases to qualified lawyers in private practices? Is the intention for the remuneration payable to external lawyers under Clause 6 of the bill to be fixed under subsidiary regulations, or will that be subject to another consultation? There is also an overlap between the space that PDO will occupy and the space occupied by volunteer lawyers who take up criminal defence cases pro bono. Have there been any studies on whether there are particular types of criminal defence cases that private practitioners are more willing or less willing to take up pro bono? From an efficiency standpoint, the PDO should complement the existing pro bono efforts of our lawyers and multiply the potential reach of criminal legal aid in Singapore. As the PDO is also aimed at developing expertise, building up institutional knowledge and access to expert witnesses, medical and forensic analysts, and so on, will private lawyers volunteering under CLAS be allowed to tap on PDO's precedents and knowledge? This would reassure the public that there will be minimal difference in outcomes to prefer the criminal legal aid provided by PDO or that provided by volunteer lawyers through the schemes like CLAS. Finally, what were the considerations behind the structuring the PDO as a department of the Ministry of Law with the Chief Public Defender who is appointed by the Minister for Law? I ask this primarily because I'm concerned that the Chief of Public Defender's decisions to grant or not grant aid may potentially be politicized, especially where specific individuals or offences are involved. Such concerns would have been substantially reduced if the PDO and Chief Public Defender had been given an independent role under the Singapore Constitution. As a famous saying goes, justice must not only be done, but must also be seen to be done. Mr. Deputy Speaker, sir, notwithstanding the clarification sought, I support the bill. Thank you.